You've already been deposed in a lawsuit and you want to know, can I be deposed again in the same case? Hi, I'm Frank Nunes, a California civil trial attorney practicing law in the state of California. Well, generally in California, the rule is there can only be one deposition per witness unless there is good reasons to do it again. That usually requires a court order or an agreement by the parties. So once your deposition is concluded, once the lawyers have finished with the deposition, for the most part you're done. Some of the exceptions that can come up is if there's a new party that's later added to the case, that person can come in and ask you questions through their attorney or through themselves if they are self-represented that were not covered in the prior deposition. Typically they limit those questions to new material. Practically speaking, sometimes old material is recovered, so that's why it's important to go over your testimony from your first deposition to make sure you're consistent. Common reason for a party to get redeposed in a case is when the party that set the deposition or invited everybody to come to the deposition failed to notify a party that he or she knew was already part of the lawsuit. That party says, hey, I wasn't invited, I didn't know what the witness's testimony was. Then the burden is on the party who noticed the deposition to show why he or she did not notice that party that wasn't invited to the deposition. Well, that's it for today's video on how many times you can be deposed in a case. By the way, if you found this information helpful, subscribe to our YouTube channel. Why? So you can continue to get great new content every time we post another great educational video. And if you have questions, I want you to pick up the phone and call me. I can answer your questions. I answer questions like this every day. You can reach me at 559-436-0850. I'm Frank Nunes, and thanks for watching.